We're here for the court to deal with three specific motions as it relates to this case now that the dog has been discussed. There's a motion to suppress, which is really 8 motions to suppress within one on various angles. The state has responded to each of the 8 branches of the motion. What I'm going to discuss today, and this opening statement refers to one of them. Specifically, the motion to suppress dealing with the Stafford Law Office, the search that occurred on April 22nd of 2014. The defense has alleged that when law enforcement entered the office, law enforcement searched the office prior to obtaining a warrant to then search the office. They have not challenged the warrant. They have not challenged the search after the obtaining of a warrant. They've challenged the actions of law enforcement before the warrant was obtained. And so that's what the state will focus on today. The state's going to call retired Special Agent Gregory Curtis of the FBI, who was assisting with the Cuyahoga County Sheriff's Office, investigating the bomb threats that were made to the Cuyahoga County Domestic Relations Court on July 10th of 2012. That investigation was still happening, and what you're going to hear is testimony from Special Agent Curtis, where law enforcement had an individual who was working at Stafford Law, who was informing with them, and told them that day, on April 22nd, 2014, that the place was going crazy. They were shredding documents, and they took Greg Moore out to lunch, and people were searching and people were shredding, and the place was crazy. This person told law enforcement felt there were exigent circumstances, so they went in and to Stafford Law and informed everyone to stop doing what they were doing until they could get a warrant. And you'll hear Special Agent Curtis. He was there. He's the one who told them. Everyone stop. He did not search anything. He ensured the destruction of evidence ceased. And then when the warrant came, which did come, an actual search then occurred. You'll hear that from Special Agent Curtis himself. And we'll talk about a couple of things that were seized at that time. That will be the testimony with regard to that branch of the suppression motion, and there will be no reason to suppress anything from that search. And you've got the warrant. The warrant is actually State's Exhibit 5, which has been submitted to the court already. The warrant itself describes the exigent circumstances in the affidavit and the warrant itself. So the judge who signed that understood the exigency of the matter, which clearly occurred before they got the warrant. Nothing in that warrant, nothing in the affidavit comes from any type of search that occurred at the office prior to getting the warrant. It just didn't happen. Did not happen in the way the defense says so. So that's going to be our testimony. We're going to proffer with the first witness. The second witness, Judge, will be Special Agent Heather Carl with BCI. Her testimony will relate to the other motions, speedy trial and pre-indictment delay. And what you'll hear from Special Agent Carl is what BCI did when they got this case. The court, you are aware of the long procedural history with regard to this defendant. He was originally indicted in 2015 with regard to bomb threats. That expanded in subsequent indictments to cover some crimes related to his interactions with his client, his legal client, Elisa Sherman, on March 24th of 2013, the day she was murdered. He was never charged with any violent offense towards Elisa Sherman. After those cases were resolved, the murder investigation continued, and then BCI officially picked it up in 2021. They were brought in to consult in 2018, they picked it up in 2021, and then began investigating again. You'll hear that from Special Agent Carl. How they began, what they did, the fact that they executed 120 search warrants of their own. The evidence that they gathered, new evidence that they found, and it gave a new understanding of the case. Specifically, the evidence they found pointed and proved matters of consciousness of guilt that did not exist, that were not known to law enforcement in 2013, 14, 15, 16, until they obtained a specific document in 2023. And that document was the Verizon customer notes related to the Stafford Law Office Verizon phone account. You'll hear testimony, Judge. A lot of times, cold cases are broken through DNA testing that, you find some DNA on an item that was never tested, or you have advancements in DNA, that sort of thing. That is not what happened here. What happened here was the obtaining of certain documents, one of which was these customer notes, which had not been obtained by any law enforcement until 2023. And they gave an understanding as to timing of when things were happening and what actually was happening behind the scenes that nobody knew until 2023. You'll hear that testimony from Special Agent Carl. Specifically, what they discovered was a pattern of the hiding of and destruction of evidence by Greg Moore and by others helping him, allowing him to do this. What you'll hear, Judge, is that, and this actually relates to Special Agent Curtis's testimony. He's going to testify about the search of the Stafford Law Office. One of the things that was found in the office that day was on Vince Stafford's desk a motion for in-camera inspection of Greg Moore's cell phone records, filed with the court on December 27, 2012. Why is this important? This motion was sent to Greg Moore, who was the target of that investigation. And it's actually on the document itself. There's a certificate of service saying that the prosecutor's office, in a document entitled State of Ohio versus Gregory Moore, sent it to him. When they searched the office on April 22nd, 2014, that document was sitting on Vince Stafford's desk. It was collected, scanned in, and kept as evidence. Fast forward to when BCI picks up this case. And they are obtaining more information. One of the things they obtained is an email that was sent from one of the Stafford employees to Greg Moore and Ann Fantelli, the other lawyer who worked there while Joe Stafford was suspended. Dated January 2nd, 2013, 11:45 a.m. And this employee emailed Greg Moore and Ann Fantelli saying, "We just received a motion for in-camera inspection of cell phone records," and described the content of this motion in this email to Greg Moore and Ann Fantelli. January 2nd. One of the other things Special Agent Carl was able to do was to take a device that was recovered in that search of the Stafford Law Office in 2014, Joe Stafford's iPhone. You'll hear Special Agent Curtis testify. Mr. Stafford refused to give his code and to allow law enforcement to open his phone and download the contents that day, which was his right. He exercised his right, and the phone was not downloaded that day. And it sat in evidence for over a decade until BCI took it and obtained the services of Cellbrite, an outside company, sent the phone to them, paid a fee for them to open the phone. And that happened in 2025. The phone is sent back to BCI. And on this phone, there were a batch of emails. The content of those emails is not on the phone, but the date, time, to and from, and subject line of the emails are on the phone. So, back to what Special Agent Carl's going to testify to. On January 2nd, after that motion comes in, and the employee sends an email to Greg and Ann saying, "We just got this motion." Well, another email is sent to Joe Stafford. And then other emails are sent. The next day, January 3rd, the Verizon customer notes, which BCI recovered in 2023, show that at 7:20 p.m. on January 3rd, Greg Moore was authorized to get a new phone on that Verizon account. The bomb threat phone, the phone he used to make bomb threats, was never recovered by law enforcement. Law enforcement's coming for information, he gets a new phone. The next day, January 4th, those same Verizon records obtained in 2023 show that Joe Stafford authorized Greg Moore to take over the assumption of liability, the use of a mobile broadband device that Stafford Law had had since 2025 and had never been in his name, in Greg Moore's name, until January 4th, 2013. That's what those records show. Then, back to evidence we already knew, which was Elisa Sherman's phone. It was recovered on the day of her murder. It was downloaded by Cleveland police back in 2013. And the text messages between her and Greg Moore were all there on her phone. The next day, March 25th, Monday. New information, again, from Stafford, the Verizon customer, showed that on that day, March 25th, the day after Elisa Sherman's been murdered, the Monday of that week, the day this law firm is now working on and dealing with their client's murder outside their office, someone from Stafford Law called Verizon and tried to cancel that mobile broadband device. Day after the murder. Another item BCI recovered in their investigation were all of the Verizon bills from Verizon that were sent to the Stafford Law office for that account that whole time. And those bills show certain usage of devices. It showed the monthly billed usage of the mobile broadband devices that Stafford Law had. They had two. The one in Greg Moore's name had been used for 1 gigabyte worth of data transfer that month, March of 2013. Those records also show that device was then never used again until it was officially canceled in August of 2013. But those records showed that the day after the murder, someone from the office called to cancel this device. Now let's go back to the search of the law office. Another item that was recovered, the value of which was not known at the time, was something recovered from Greg Moore's desk on April 22nd of 2014. A receipt for a Verizon broadband device. July of 2010. That's the device that was put in his name in January of 2013. With that was a note. A note that said, Marge, cancel this if Joe or Vince don't need it for their laptops. Marge is the one who the Verizon customer notes show called in to try to cancel that device the morning after Elisa's murder. This is all new information. Additionally, a pattern was developed and discovered. Because another thing that was known at the time, April 1st, a supervisor with the Cuyahoga County Prosecutor's Office sent Greg Moore and Joe Stafford a letter and a grand jury subpoena for communications with Lisa Sherman. Evidence. The subpoena was dated March 28th of 2013. The letter was dated April 1st, 2013. That was received at Stafford Law, and Joe Stafford's phone, which was not cracked into until last year, showed him getting an email on April 2nd regarding a Cleveland police request for records. Later that day, April 2nd, Joe Stafford's Verizon bill, which was recovered by BCI in their investigation after 2023, showed some calls coming in to him on April 2nd. One was from Greg Moore's wife's phone number. Another was from a Verizon customer rep's number, which coincided with that day, April 2nd, Joe Stafford authorizing Greg Moore to get another new phone. So now the phone he had when Elisa Sherman was murdered is now gone. Never recovered by law enforcement. And no one ever knew that, and when he got rid of it, until these customer notes were found by BCI in 2023. So, that's some of the testimony you'll hear from Special Agent Paul as to the development of new evidence, a new understanding of efforts to hide evidence, get rid of evidence. When police come looking for it, they get rid of it. And now we know that, which goes to consciousness of guilt, is something that police, law enforcement never knew when all of the grand jury proceedings were happening in 2013, 14, and 15, and 16. And he was never charged with murder at that time. So all of that is going to go to speedy trial. It's going to go to pre-indictment delay. And there's one other thing I'd like to discuss with regard to speedy trial and pre-indictment delay. This effort to hide evidence and control the narrative. Greg Moore's house was searched after his arrest in Texas last year. One of the items recovered was a computer, laptop computer. On that computer, police, BCI recovered old BlackBerry recovery files with a date of May 22nd, 2014. And this was, these were backup files of Greg Moore's, the phone he had when Elisa Sherman was murdered, his call logs for the month of March and up to April 2nd when they stopped. SMS messages during that time frame and contacts. But there are some items on there that are reflected in his Verizon records, if you cross-reference, and some items that are not. But this was found on his laptop computer, something he saved for over a decade. And within the text messages to and from Elisa Sherman, there's one missing. A message she sent at 5:16 p.m. the day she's murdered, and she is murdered at precisely 5:20. She is stabbed at precisely 5:23, 5:24. She sent a message at 5:16 to Greg Moore, which is reflected in her phone extraction, saying she's at the door. Why won't you let me in? It is not on his backup, and it was not in text messages he sent to himself and printed up and were found in the office when it was searched in April of 2014. So these are some of the things we want the court to consider as new evidence, a new understanding of the case that occurred when BCI picked up the file in 2021. And finally, I'd like to add, when it comes to pre-indictment delay, one of the major factors that must be considered is whether there is actual prejudice to the defense. We all know kidnapping has a 20-year statute of limitations. Murder has no statute of limitations. So this indictment, last year, indicting him with kidnapping and murder from 2013 is not time-barred. So there's nothing wrong with this as far as statutory law. They're saying they're prejudiced. They will not show this. There's no witness who's not available to them now that would be necessary. There's no prejudice to them, because one of the things we are going to offer into evidence, we're not going to play it here, I've described it in the motion, and we'll put it on a flash drive for the court, is a press conference that defense counsel did the day of the arraignment, in this case, last year. After the defendant was arraigned, counsel went outside and spoke with the media for 5 minutes and 6 seconds. It was recorded, put online, you can find it today. And we've recorded it for you, we're going to give it to you in evidence. In that little press conference, defense counsel said multiple times, there will be a trial. There will be a trial in this case. They're not saying, this case has taken too long, we can't possibly go to trial, we have actual prejudice. No, they're not saying that. There will be a trial. And the day of the arraignment, they said, we have evidence today that can prove what they're saying is not true. So I ask you, Judge, when you watch this press conference, ask yourself, what changed between the day of arraignment and now such that they cannot go to trial? They promised a trial then. How is it possible they can't go to trial now? And you will find they won't prove that to you. And with that being said, we look forward to bringing evidence. Thank you.